My daughter spent 7 years stealing my house. Not with threats. Not with lawyers. Not by breaking into a bank account. She did it one signature at a time. The worst part wasn't discovering her name on my property records. The worst part was discovering it had been there for 6 years before I noticed. For 6 years, ownership of the home my husband and I spent 35 years paying for had been quietly changing behind my back. And by the time I found the first document, my daughter already believed the house belonged to her. What she didn't know was that she had left behind a paper trail so detailed, so arrogant, and so impossible to explain away that it would eventually destroy her in a courtroom full of relatives. My name is Evelyn Parker, and this is how I discovered that my only child had built her entire future around stealing mine. The mail comes at the same time every day. 2:20, give or take 10 minutes, depending on whether Mr. Castellanos down the block stops the carrier to talk about his knees. I've lived in this house long enough to know its rhythms the way you know the creak of your own stairs. 9 years alone in it now, and I could probably tell you what day of the week it is just by listening to the sounds outside. That Tuesday I was at the kitchen table, the same table Harold built the year we moved in, sanding the edges himself so the kids wouldn't get splinters. I was going through the usual stack. A flyer for a gutter cleaning service. A catalog I never asked for. A birthday card from my sister Phyllis, 3 weeks early as always. And underneath all of it, a plain envelope from the county assessor's office. I want to be honest with you. I almost didn't open it that day. I get one every year. Property tax assessment, same beige envelope, same return address, same dry language about market value and millage rates. Most years I glance at the bottom line, see that it's gone up again like it always does, and slide it into the folder where I keep that sort of thing. I have folders for everything. Harold used to tease me about it. He'd say, "Evelyn, you've got more filing systems than the post office." But those folders have saved me more than once, and old habits, when they're good ones, are worth keeping. So I opened it. Standing right there at the counter, letter opener in hand, the one with the little brass owl on the handle that an old friend gave me for Christmas some 20 years back. The first page looked exactly like it always does. Parcel number. Property address. My address, the one I've had since 1991. Assessed value, which had climbed again, not that it matters much when you have no intention of selling. I started to fold it back up. My hand was already moving toward the folder. And then my eye caught the ownership line. It's funny the things you notice without meaning to. I wasn't even reading carefully. I was on autopilot, the way you are with a document you've seen 40 times before. But something about that line looked different, and before I could name what it was, I was reading it again, slower this time. Property owners, Evelyn R. Parker and Danielle Hughes. I read it a third time after that. Not because the words had changed, because I was waiting for them to. For a moment, and I mean this honestly, not as something I'm saying now to make myself sound foolish. For a moment I thought it was a mistake. A clerical error. I pictured some overworked clerk in a windowless office, typing names into a database, fingers moving faster than their attention, and somehow my daughter's name had ended up where it didn't belong. These things happen. I'd read about it in the newspaper once. A man in Ohio whose house got listed under a stranger's name for almost a year before anyone caught it. That was my first thought. I want you to understand that. My first thought was not betrayal. My first thought was bureaucracy. I set the letter opener down and reached for my reading glasses, the ones that live in the little dish by the fruit bowl, and I sat back down at the table. Outside, I could hear Mrs. Fitzgerald's wind chimes, the ones that sound a half step off no matter which way the wind blows. I remember that sound specifically because I was listening to it while I read the rest of the page, trying to find the part that would explain everything away. There's a section on these notices, smaller print, near the bottom, that lists any changes to the property record since the last assessment. Most years that section is blank. Mine has been blank every year I can remember. This year it wasn't. It read, Ownership Amendment Recorded, Filing Reference 0934A, dated approximately 6 years prior. I sat with that for longer than I'd like to admit. Because here's the thing about a date like that. A date like that doesn't ask you a small question. It asks you a large one. If this was a mistake, a fresh one, a recent slip of someone's keyboard, then fine. Mistakes get fixed. You make a phone call, you fill out a form, someone apologizes, and by Friday it's as if it never happened. I could have lived with that kind of mistake. I could have laughed about it, even told Phyllis about it on the phone, the way you tell someone about a wrong number or a misdelivered package. But this wasn't fresh. Whatever this was, it had been sitting in the county's records for roughly 6 years. 6 years of tax notices, 6 years of assessments, 6 years of this envelope arriving at my door every spring, and I had never once looked closely enough to see it. I thought about every one of those envelopes. I thought about the kitchen drawer where I keep the older ones, going back further than I probably need to. I thought about how many times I had opened one of these, glanced at the total, and filed it away without a second look. Because why would I look twice at something that had never given me a reason to? I sat at that table for what felt like a long time, though when I checked the clock later it had only been about 4 minutes. The house was very quiet. It's always quiet in the afternoons, but that day the quiet felt different. It felt like it was waiting for me to do something with it. I looked at the date again. Roughly 6 years. I did the arithmetic without meaning to, the way your mind does when it's trying to protect you from a conclusion, working out the math first so the feeling has somewhere to land. If my daughter's name had been attached to my home for 6 years, quietly, without a single word to me about it, then I had to ask myself a question I did not want to ask. What else had happened during those 6 years that I never saw? I didn't sleep much that night. Not in the dramatic way people describe it in movies, tossing and turning, sheets twisted into knots. I slept the way I always sleep when something is sitting unresolved in the back of my mind, lightly, in pieces, waking every hour or so to find the ceiling exactly where I left it. By morning I had decided something. I was not going to call Danielle. I want to explain that decision because I know how it might sound. My daughter's name was on a legal document attached to my home, a document I had never seen, filed roughly 6 years ago without my knowledge. The obvious thing, the natural thing, would be to pick up the phone and ask her about it directly. Danielle, did you know there's an ownership amendment on the house from years back? Do you know anything about that? But I have spent 38 years working with children, Danielle included, and if there's one thing that work taught me, it's this. When you ask someone directly about something and you're not yet sure what you're dealing with, you give them time to prepare an answer. And a prepared answer tells you nothing. So instead, I made a pot of coffee. The percolator, not the machine, because the percolator takes longer and I think better while I'm waiting for it, and I sat down with my own memory instead. I started simply. I asked myself, when is the earliest I can remember Danielle being involved with anything related to this house, the paperwork side of it, not just living in it? The answer came almost immediately, and it surprised me how fast it came, because I hadn't thought about that particular afternoon in years. It was about 3 weeks after Harold's funeral. I remember the kitchen still smelled faintly of the casseroles people had been dropping off. Every neighbor for 2 streets brings a casserole when someone dies, did you know that? You end up with more chicken and rice than one person could eat in a month. I remember the dining room table covered in folders. Insurance paperwork. The deed. Bank statements. Harold's will, which our attorney, Mr. Donnelly, had already gone over with me once, though I'll admit very little of it stayed in my head that week. Grief does that. It's not that you're not listening. It's that your mind has put up a kind of glass between you and the world, and things slide off it instead of going in. Danielle came over that Saturday. I remember it was a Saturday because she had Greg drop her off and pick her up later, which was unusual because back then they still only had the one car between them. She sat down across from me at that table and she said, "Mom, let me help you sort through this. You shouldn't have to do this alone." At the time, I thought it was one of the kindest things anyone had done for me that whole month. She went through the folders with me. She'd pick up a document, read it aloud, ask me a question or two, and then either set it in a keep pile or a file away pile. I remember her voice during that. Gentle, patient, the kind of voice you'd use with someone recovering from surgery. She kept saying things like, "Don't worry about this one, Mom, it's just routine. And this is standard, every homeowner has to update this eventually." There was a moment, and this is the memory that kept surfacing all morning, no matter how many times I tried to set it aside and move on to something else. There was a moment where Danielle had a small stack of her own papers separate from mine sitting near her elbow. At one point she slid 2 or 3 sheets from that stack into the pile of documents I was signing. I remember the sound of it, actually, paper against paper, that soft sliding noise. And I remember glancing up and she said without my even asking, "Just some administrative forms, Mom. For the estate transfer. Mr. Donnelly's office needs them." And I signed them. I signed them because I trusted her, and because I was exhausted in a way that went deeper than tired, and because my husband had been dead for 3 weeks and my daughter was sitting across the table from me handling things so I wouldn't have to. I remember being grateful. I remember thinking not for the first time that I had raised a good daughter, a capable daughter, someone who showed up when it mattered. I sat with that memory for a long time over my coffee, turning it over the way you'd turn over a stone you'd found on a beach, looking for the side that explains why it caught your eye. Once I'd found that memory, others started arriving, almost as if they'd been waiting for permission. I remembered maybe a year or so after that mentioning to Danielle that I hadn't received a piece of mail I was expecting, something from the homeowner's insurance, a renewal notice. She'd said, "Oh, I think I saw something like that come through, I'll check." And then nothing more was said about it, and I never thought about it again until this morning, sitting at my table with my coffee going cold. I remembered a dinner a few years ago where Danielle had been talking about, when the time comes, about the house, about how big it was for just one person, about how she and Greg had been looking into what it would take to add a second unit out back for resale value, down the road. At the time I'd taken it as the kind of idle talk families do. Everyone has opinions about everyone else's house. I remember even agreeing with her about the second unit, said it might be a nice project for someone someday, not really thinking about who someone was supposed to be. I remembered more recently a conversation about the property taxes going up and Danielle saying almost in passing, "I'll look into it, Mom, I know a guy at the office who handles this stuff all the time." I never followed up on whether she had. I never asked. None of these things on their own were anything. I want to be fair about that. People say things. Families joke. Children help their aging parents. And sometimes that help comes with opinions about the future that nobody really means as more than conversation. But sitting there that morning with the coffee gone lukewarm in front of me and that filing date sitting in my mind like a stone I couldn't put down, every one of those memories looked different than it had the day before. Lined up next to each other, they didn't look like coincidence anymore. They looked like a pattern. And the very first piece of that pattern, the very first one as far back as I could trace it, was that Saturday at the dining room table 3 weeks after Harold died, with Danielle's voice saying gently, "Just some administrative forms, Mom." I kept coming back to that moment. Over and over all that day and into the next, my mind returned to that table, that stack of papers, that soft sliding sound. Memories, though, even memories that line up perfectly, even memories that make your stomach turn cold when you look at them in a new light. Memories aren't proof. I knew that. I'd spent too many years helping children write reports to not know the difference between a feeling and a fact. So I did the only thing that made sense to me. I called the county records office and requested the complete title history of the property. Every document, every filing, everything on record since the day Harold and I bought that house. They told me it would take a few days to compile. 3 days later, a thick envelope arrived on my doorstep, and when I opened it, everything I had spent 2 days only suspecting suddenly had a name, a date, and a signature attached to it. The envelope from the county records office was heavier than I expected. Manila, the kind with the little metal clasp on the back. I brought it inside, set it on the kitchen counter, and made myself a cup of tea before I opened it. Not procrastination, just preparation. I sat down at the dining room table and opened the envelope. Inside was a cover letter from the assessor's office, businesslike, listing what was enclosed. Below that were the documents themselves, organized by date, oldest first. The first document was familiar. It was the original deed from 1991 with Harold's signature and mine, side by side, the way they'd looked for over 30 years. Seeing our names together like that, his handwriting, that confident slant he always had, mine smaller and more careful beside it, took me a moment. I hadn't seen his signature in a long time. I set that page aside and moved to the next. The second document was dated about 8 months after Harold's death. Titled, in plain block letters, Limited Power of Attorney, Property Matters. It granted Danielle the authority to act on my behalf in matters related to the management, maintenance, and administrative filing requirements of the property. My signature was at the bottom. I had no memory of signing it. None. And I have a good memory for paperwork. It's one of the only things these days that I'm confident about. I thought about that Saturday again. The casseroles. The folders. The soft sliding sound. Just some administrative forms, Mom. The third document was dated about 2 years later. Amendment to property title. Addition of joint tenant. Dense legal language. Grantor reserves, subject to the terms herein. But underneath it, what it said in plain terms was this. The property was no longer held solely in my name. As of that filing, it was held jointly. Myself and Danielle Hughes. My name was on it. Grantor signature. Evelyn R. Parker, in handwriting that, at a glance, looked exactly like mine. I told myself, that's my signature. Of course it is. I must have signed it. I just don't remember. But I kept it. Set it aside in its own pile and kept reading. The fourth document was dated about a year after that one. Another amendment, ownership percentages, shifting the split from 90-10 in my favor to something closer to even. Again, my signature at the bottom. Again, that same uncomfortable familiarity. The fifth document was filed just under 2 years ago. This one restructured decision-making authority regarding the disposition of the property, handing controlling say to Danielle, with my role reduced to what the document called, almost gently, co-interest holder. And then there was a sixth page. The most recent of all. Filed less than a year ago. Titled Refinance Authorization, Existing Mortgage Lien Release. It granted Danielle the authority to negotiate on my behalf a new line of credit against the property. The final piece I would understand much later, that would have let her pull cash out of the house before it ever needed to be sold. By the time I finished reading that sixth document, I had 6 pages spread out in front of me on the table, each one building on the one before it. This was not one bad afternoon. This was 5 separate amendments over roughly 7 years, each one a small, almost invisible step. A power of attorney here. A joint tenancy there. A percentage adjustment. A transfer of decision-making authority. And finally, a refinance authorization. The key that would turn the house into cash. Each one reasonable sounding on its own. Each one by itself the kind of thing a busy clerk might glance at and stamp without a second thought. But together they were a staircase. and every step led in exactly one direction, away from me and toward Danielle. I sat there for a long time without moving. Then I went and got the small box where I keep old cards and letters. Birthday cards. Mother's Day cards. A card from when I retired from the library. I brought them back to the table and laid them down next to the property documents, and I started comparing signatures. Danielle's on the cards and mine on an old retirement check, next to mine on those 6 filings. First they all looked the same. Truly. My signature is my signature. I've been writing it the same way for 50 years. But I kept looking. I picked up the oldest of the documents, the power of attorney, and held it next to the check under the lamp where the light was better. And there was a tiny hesitation in the curve of the E. A place where my real signature flows in one smooth motion, but the one on the document paused. Just slightly. Just enough that the ink was a fraction darker there. I had signed my name tens of thousands of times in my life. I had never once paused in the middle of that letter. I sat back in my chair, the cards and documents spread out in front of me, and I felt something settle in my chest. Not panic, not yet. Something quieter and colder than that. The understanding that whatever this was, it was not a mistake, and it was not one moment of bad judgment on a hard day. It was a pattern. And patterns don't happen by accident. I want to explain something about myself before I tell you what I did next. For most of my life, when I've been hurt by someone, my instinct has not been to confront them. It's been to understand them. I spent 38 years in elementary school libraries, and if you've ever worked with children, you know that the worst thing you can do when something goes missing is walk into the classroom and demand a confession. Children close up. They get scared, and scared children lie, even good ones. What works is patience. You watch. You let the truth surface on its own schedule, not yours. I don't say this to compare my daughter to a child who took something from a lost and found jar. What I'm describing here was much larger than that. But the instinct was the same, and it was the instinct I followed. I did not call Danielle. I put all of it, the deed, the 6 documents, the cards, the check, into a folder and put that folder in the cedar chest in my bedroom under the quilt my mother made. And then on a Thursday morning I called a man named Arthur Beasley. I'd gotten his name from Mr. Donnelly, the attorney who'd handled Harold's estate. Mr. Donnelly had retired since, but I still had his number. Real estate fraud is his whole practice now, Evelyn, he told me. If something's wrong, he'll find it. And if nothing's wrong, he'll tell you that too, and you can sleep easier. Arthur's office smelled like coffee that had been sitting too long on a warmer. He was younger than I expected, maybe 50, reading glasses pushed up on his head, a voice that was steady without being cold. I laid out the folder for him. He didn't say much while he looked through everything. He took notes. At one point he held the power of attorney up to the window, the way I had held it up to the lamp, and I saw something pass over his face. Not surprise. More like recognition. Mrs. Parker, he said when he'd finished, I think you're right to be concerned. I'd like to bring in a couple of specialists. A forensic document examiner to look at these signatures properly. And, if it comes to it, a forensic accountant, to trace where the money for filing these kinds of amendments would have come from. Recording fees, notary fees, attorney consultations. If someone else was managing all this, there'll be a paper trail for that too. And Mrs. Parker, he added, I'd recommend you not mention any of this to your daughter in the meantime. If there's an innocent explanation here, the documents will show that, and nothing's lost by waiting. And if there isn't an innocent explanation... He didn't finish that sentence. He didn't need to. The forensic document examiner's name was Linda Choi. She came to Arthur's office about 2 weeks later. She spread my documents and cards across the conference table in a particular order, the way I imagine a doctor lays out instruments before a procedure, and worked mostly in silence for the better part of an hour. Mrs. Parker, she finally said, I want to walk you through what I'm seeing here, and I want to be precise because precision matters in this kind of finding. She turned her laptop so I could see the screen. 2 images side by side. My signature from the retirement check enlarged, and beside it the signature from the power of attorney enlarged the same way. A natural signature has dynamic pressure variation. Your pen speeds up and slows down in a consistent rhythm. It's almost a fingerprint. You can see it here in the check. The pressure builds through the loops of the E and the P, and tapers off naturally. She moved her finger to the other image. This signature doesn't have that. The pressure is almost uniform throughout. And here in the, she pointed to the same small hesitation I'd noticed under my lamp, now magnified until it looked like a tiny lake of ink. You can see a pen lift artifact. The line breaks here microscopically in resumes. That happens when someone is tracing, following the outline of an existing signature, lifting the pen at the points a tracer naturally pauses to check their position. 2 more of the documents, she said, showed the same tracing characteristics. The most recent, the refinance authorization, was different again. This one shows characteristics consistent with mechanical reproduction. A stamp or a printed signature transferred onto the page. The ink saturation is completely uniform, edge to edge, in a way that's essentially impossible to produce by hand. Didn't feel like anger. Not yet. It felt like the floor of a room you've lived in your whole life turning out to be built over a basement you never knew was there. Arthur saved the worst part for last. The percentage adjustment amendment had been notarized. A notary's stamp on the final page, certifying that Evelyn R. Parker had appeared in person on a specific date to sign it. I pulled the notary's logbook, Arthur said. It's a public record request. And Mrs. Parker, the date on this filing is October the 14th. Do you remember where you were on October the 14th a few years back? Keep a calendar, I always have. I went home and found the right year and turned to October. Drive up to Marion's, stay through the 17th. Marion is my husband's cousin. 200 miles north. I still had the gas station receipt from that trip, dated October the 14th, from a station 30 miles outside Marion's town. 200 miles away. On the day a notary swore I had stood in front of them and signed my name. I sat at my kitchen table that night with the forensic report, the notary log, my old calendar, and that faded receipt in front of me, and for the first time since the beige envelope had arrived, I let myself say the word out loud alone in my own kitchen. Fraud. It wasn't suspicion anymore. Someone had traced my signature more than once. Someone had arranged a false notarization. Someone had built piece by piece over years a legal structure quietly handing away my home. But I still didn't have the answer to the question that mattered most. Danielle is my only child. Everything I have was always going to come to her one day. So why would she risk this much? Forged signatures, false notarizations, years of careful filings, for something that was already going to be hers? I didn't have an answer. Not that night and not for 2 more weeks. And then, on an ordinary Tuesday afternoon, while I was at Danielle's house returning a casserole dish, I found myself alone in her kitchen for just a few minutes, and I saw that her laptop was open and still logged into her email. I want to tell you about a Sunday dinner. It was about a week after I'd sat with the forensic report and the notary log. I hadn't said a word to anyone. Arthur's team was still working. He'd mentioned wanting to bring in a forensic accountant next, but said it would take time. So I went to Sunday dinner the way I do most weeks. Phyllis was there, and so was my nephew Mark and his wife. Danielle had set the table nicely, cloth napkins, the good plates. Pot roast. Greg pouring wine. Somewhere between the pot roast and the dessert, Danielle said something that 6 months earlier I would not have noticed at all. Phyllis had asked about my roses, which hadn't done well that summer. And Danielle said without any particular emphasis, "Oh, we've actually been talking about taking that tree out when we redo the landscaping. Once we get the back unit built, the whole side yard is going to need to be reworked anyway." The back unit. I sat there with my fork halfway to my mouth and I didn't react. I have spent a lifetime not reacting. I simply kept eating and I listened. Greg nodded along, refilling his glass. "Half the houses on this street have done some kind of addition," he said. "We'd be foolish not to think about it." Mark asked, innocently, "Is that something you guys are doing to your place, or?" A small pause. Then Danielle, "Well, eventually to Mom's place. It's basically going to be ours at some point anyway, so it makes sense to start thinking about what we'd want to do with it." Phyllis laughed. "Well, Evelyn's not going anywhere for a long while yet, I hope." Everyone chuckled and the conversation moved on. But something had been said. And I had heard it. Over the following weeks, I started noticing it everywhere. Our property taxes. Danielle telling Phyllis she'd had someone come look at the house to see where the market's at. I said nothing. Arthur had been right. If I said something now before the investigation was complete, I would only be handing her time to explain things away. And then came the casserole dish. I'd brought a casserole over a few weeks earlier, and told Danielle I'd come by Tuesday to pick up the dish. When I got there, she texted that she was running late, doors unlocked, go on in. So I let myself in the way I've done 100 times and went into the kitchen. On the counter, next to a mug of coffee still slightly warm, was Danielle's laptop. Screen dimmed, not locked. I am not a person who goes through other people's things. I never have been. But I had a reason now. I reached over, touched the trackpad, and the screen brightened. An email account logged in. At the top of the inbox, a folder I hadn't expected. House plans. I clicked it. Dozens of emails. Between Danielle and Greg, and between Danielle and someone whose signature line read, Senior Associate Halloran and Vance Properties. I scrolled. Ownership split currently sits at. Once the percentage adjustment is recorded, the next step would be projected valuation if listed within the next 18 to 24 months. A message from the Halloran and Vance contact described a buyer interested in an off-market acquisition in our neighborhood, and said that if our situation was moving toward resolution, they could fast-track a private sale before it ever needs to hit the open market. This was not a someday plan. This was a buyer, a name, a window of time. And then, near the bottom, an email from about 2 years ago. Subject line, timeline. I read one sentence near the end. I read it again to make sure I hadn't misunderstood it. I hadn't. Once the title changes are done, she won't have a choice. I stood there in my daughter's kitchen, holding nothing, touching nothing now, just looking at those words on the screen, and the warm coffee mug and the dish towels folded just so, and I heard very clearly and very far away the sound of a car pulling into the driveway. The car door closed and I heard Danielle's footsteps on the gravel. I closed the laptop, gently, careful not to lose the page, and stepped away from the counter, picking up my casserole dish from the drying rack just as the back door opened. Sorry, Danielle said, coming in with her keys still in her hand. Traffic was a nightmare. Did you find your dish okay? I did, I said. Thank you for taking care of it. She glanced at the laptop without any reaction, asked if I wanted coffee. I said I couldn't stay and left within a few minutes, my dish under my arm, my heart doing something in my chest that I didn't examine too closely until I was back in my own driveway, engine off, hands still on the wheel. I called Arthur the next morning. I told him what I'd seen. The folder, the emails, the buyer, the line about title changes and choices. I told him I hadn't taken anything, hadn't photographed anything, hadn't touched anything beyond opening that one folder. I wanted to be careful. How something is discovered matters almost as much as what is discovered. Arthur was quiet for a moment. Mrs. Parker, I think it's time we bring in the forensic accountant I mentioned. His name was Felix Okonjo, the best I work with, Arthur said. His job over the following weeks was to follow the money, the recording fees, the notary's fee for the filing that placed me on paper 200 miles from where I actually was. It took him about 3 weeks. When he came back, he came with Arthur to my house, to the same dining room table where I'd first laid the documents out under the lamp. Every one of those 5 amendments cost money to record, Felix told me. Recording fees, notary fees, in one case a courier fee for expedited processing. I traced all of it. Every single payment came from an account in Danielle Hughes's name. Not joint with Greg, her own personal account. The earliest payment is from about 6 months after your husband passed. 6 months. The power of attorney had been filed about 8 months after Harold died. 6 months was before that. 6 months was while the casseroles were still showing up at my door. There's something else, Felix said, sliding a printed page across the table. An email thread Arthur's team obtained by subpoena, once we had enough to support one. The same Halloran and Vance Properties name, but more of it now. Whole threads going back almost 3 years. Specific numbers. Projected sale prices broken down by scenario, as is, or after the addition Danielle had described at that Sunday dinner. A tentative listing window, Q2 of next year, with a note that the timing depended on finalizing the title situation. And Danielle's reply, Arthur had underlined it, said things were on track, that the remaining piece was just a matter of paperwork at this point, and that her mother would understand once it's explained properly, or she won't have a say in it either way. I read that line twice. Then I set the page down on the table very carefully, the way you set down something you're afraid might break if it falls the wrong way. She wasn't planning to wait until I died, I said. It wasn't really a question. No, ma'am, Arthur said. The plan was to complete the title transfer, then move toward a sale within the next year or so. There's a phrase in here, I believe from Greg, about looking into options for assisted living in the area. Framed as being for your benefit. But the timeline only makes sense if the house is sold while you're still living, and the proceeds split according to percentages that had already been quietly adjusted. What I felt wasn't rage. It was something quieter, the feeling of standing at the edge of a very large, very still body of water, suddenly aware of how much was beneath the surface. What happens now? I asked. Arthur said that between Linda's analysis, Felix's trace, the notary discrepancy, the email archive, and the developer communications, they had a complete evidentiary timeline, years, document by document, payment by payment, in order, nothing missing, nothing in dispute. Time to file. A civil action to void the fraudulent transfers, which would require a hearing. With everything we have ready, he said, I'd expect a hearing date within 30 days. 30 days. In 30 days, all of it. The folder in my cedar chest, the forensic report, the notary log, the gas station receipt, the buyer's name, the line about title changes and choices. All of it would be laid out in a courtroom, in front of a judge, in front of my family, in front of Danielle. Over the following weeks, life went on. There was another Sunday dinner. Danielle mentioned our property again, talking about square footage and the addition, with the easy confidence of someone describing a vacation already booked. I sat through that dinner the way I'd sat through the others. I passed the rolls. I let Danielle talk, because I knew something Danielle didn't know. She believed she had already won. She had no idea that every email, every filing, every payment, and every lie had already been gathered, dated, cross-referenced, and bound into a single presentation. one that Arthur's office was finishing even as she sat across from me describing the renovations she planned to make to my home. And in less than 30 days, Danielle would walk into a courtroom expecting a routine dispute, expecting to explain away a misunderstanding, expecting, I think, to win. The courthouse smells the way courthouses always seem to smell. Floor polish and old paper with something underneath that I can only describe as the smell of waiting. I arrived early, the way I do for everything, and sat on a wooden bench in the hallway with Arthur on one side of me, Phyllis on the other, and my nephew Mark a few seats down, having driven in early that morning to be there. Phyllis hadn't known what this was about until 2 days before. "I'm coming with you," she'd said in a tone that didn't leave room for discussion. I heard Danielle and Greg before I saw them. Her heels on the marble floor have a particular sound. Quick, even, confident. When they came around the corner, Danielle was wearing the navy suit she saves for client meetings, a folder of her own under one arm. She saw me and smiled. An easy smile, a little tired, the smile of someone walking into something she expects to be tedious but not difficult. "Mom," she said, lowering her voice. "I really think this is all going to turn out to be some kind of mix-up. I talked to a friend of mine who does title work and she said these kinds of filing discrepancies happen more than people realize." "I hope you're right," I said, and I meant it in a strange way. Danielle patted my arm and went to sit with Greg, near a man in a gray suit I assumed was their attorney. She didn't look nervous. If anything, she looked slightly bored. The courtroom was smaller than I expected, with the kind of quiet that makes every sound feel larger than it is. Judge Hargrove, gray-haired, reading glasses on a chain, reviewed her papers before looking up over the top of them. Arthur stood first. Calm as always. He told the judge that what the court was about to see was a complete documentary record covering 7 years, presented in chronological order, exhibit by exhibit. The first exhibit was Linda Choi's signature analysis. She walked the judge through exactly what she'd shown me at that conference table. Dynamic pressure variation, pen lift artifacts, mechanical reproduction. I watched Danielle while Linda spoke. For the first several minutes, she looked almost unbothered. But when Linda displayed the enlarged image of the E, the hesitation, the tiny break in the ink I'd first noticed under a lamp in my own dining room, I saw Danielle's posture change. Just slightly. A straightening, the kind you do when you're trying very hard to look like nothing has changed. Then came the notary log. The original filing, certifying Evelyn R. Parker had appeared in person on a specific date. Then the notary's own logbook. No entry for that date at all. Then my travel records, the gas station receipt 200 miles north, my own calendar in my own handwriting, drive up to Marion's. "Your Honor," Arthur said, "Mrs. Parker was not present to sign this document on the date it claims. She was provably 200 miles away." I heard Greg shift in his seat. A small sound, just the creak of the bench, but in that quiet room it carried. Then came the emails. Arthur read portions aloud, slowly. Ownership percentages. Valuation projections. The Halloran and Vance buyer. And then the message I had read standing in Danielle's kitchen. "Once the title changes are done, she won't have a choice." He let that sentence sit in the air. Then came Felix Okonjo and the bank records. Every recording fee, every notary fee, every cost tied to the 5 fraudulent filings, paid from Danielle Hughes's personal account. The earliest payment dated 6 months after my husband's death. I didn't look at Danielle during all of this. I looked at the judge mostly and at my own hands. But I could hear her. I could hear the absence of the small sounds she'd been making earlier, the whispers to her attorney, the shifting in her seat. The room had gone very still on that side. "Your Honor," Arthur said, "the final piece of evidence I'd like to present is an audio recording." He explained how it had come to exist. A family gathering recorded inadvertently by a relative whose phone had been left running in a jacket pocket. He played it. A few seconds. The murmur of a party. Laughter, the clink of glasses. And then clearly Danielle's voice, light and amused. The house is basically mine already. More laughter. Someone agreeing the way people do at parties, not really thinking about what's being said. The recording ended. The courtroom was silent. I looked at Danielle then for the first time since the hearing had started. She was not smiling. I had seen Danielle confident my whole life. I had never, not once in 42 years, seen her face look like it looked in that courtroom. She had gone pale. The way people go when something they've been standing on for a long time suddenly isn't there anymore. Her attorney leaned toward her and said something low. She didn't respond. She was staring at the table in front of her, at nothing. And then Arthur spoke again. Your Honor, I have one final exhibit I'd like to enter into the record. Judge Hargrove looked up. And what is that, counsel? Arthur paused, not for effect. He was a careful man, and careful men pause before important things. The complete title history of the property, he said. From the original deed in 1991, through all 5 fraudulent amendments, to the present day. Every filing, every date, every signature. In order. I watched Danielle's face when he said it. She had gone pale before. Now she looked something closer to terrified. Arthur asked permission to approach, and Judge Hargrove nodded. He set up a small screen on a stand near the witness area, unremarkable in itself except for what was about to appear on it. Your Honor, what I'm about to show the court is the complete ownership record for the property, pulled directly from the county recorder's archive. This includes the metadata associated with each filing, the date and time each document was submitted, the office through which it was processed, and the digital submission records showing how each filing was made. The first image was the original 1991 deed. Harold's signature. Filed in person, the metadata showed on a Tuesday morning in March, processed by a clerk whose initials were still legible in the corner. This, Arthur said, is what a normal filing looks like. In person during business hours, processed the same day. Then the second document, the power of attorney, filed 8 months after my husband's death. This filing was submitted electronically, through the county's online portal, at 11:47 p.m. He let that sit. Mrs. Parker does not use the county's online filing portal. She has never created an account with it. We checked. The account used to submit this filing was registered 3 weeks earlier, under the name Evelyn R. Parker, using an email address Mrs. Parker has never used in her life, but which matches almost exactly the personal email address used by Danielle Hughes, with 2 letters transposed. Behind me, Phyllis made a small sound. Not quite a gasp. More like the sound you make when you've been holding your breath without realizing it. Arthur went through the rest one by one. The joint tenancy amendment. Electronic 10:32 p.m. same account. The percentage adjustment. Electronic late at night. Uploaded, reviewed, and submitted within an 11-minute window. The decision-making authority transfer. And finally, the refinance authorization, the most recent filed less than a year ago the same way. Late at night. Same account. 5 filings. 5 times late at night someone had logged into an account bearing my name, an account I never created with an email address that wasn't mine, and submitted documents that moved pieces of my home, a little at a time, into someone else's hands. Your Honor, taken individually, any one of these filings might be explained as an error. But taken together, 5 filings over roughly 7 years, all electronic, all late at night, all submitted through an account created using a near-identical version of Mrs. Parker's own daughter's email address. each one incrementally increasing that daughter's control over the property, each one followed within weeks by communication, already in evidence, discussing ownership percentages, refinancing, and sale timelines. I don't believe this court needs to search very hard for an explanation. He stepped back. This is not a series of mistakes, Your Honor. This is a record of a plan. I looked at the screen at the timeline Arthur had built, years, laid out in a neat column, each one a small lit window into a night I had been asleep in my own bed. When I looked over, Danielle was crying. Not loudly, just sitting very still, tears running down her face, staring at the screen the way you'd stare at a photograph of yourself doing something you couldn't remember doing. Then Greg leaned toward his attorney and said, not loudly but in that quiet room everything carried, this was her idea. All of it. I told her this was a bad idea years ago. Danielle turned to him. Are you serious right now? Her voice cracked. You're the one who kept saying we needed the money. You're the one who... Mrs. Hughes. Judge Hargrove's voice cut through, not loud but final. Mr. Hughes. This is not the time. They both stopped. But the damage of it, the two of them turning on each other in front of the judge, in front of Phyllis and Mark, in front of me, didn't go away just because the judge told them to be quiet. Whatever Danielle and Greg had built together over those years had just come apart, right there in real time, in front of everyone who mattered to either of them. Judge Hargrove didn't rule that day. But within 3 weeks, the written ruling arrived. Every one of the 5 amendments was voided. The title was restored in full to me, exactly as it had been in 1991. The ruling included a finding of fraud and a referral to the district attorney's office for possible criminal charges. There were substantial civil penalties, and Danielle and Greg were ordered to cover a significant portion of my legal costs. Word got around the family the way it does. Some of the relatives who had sat at those Sunday dinners, who had laughed when Danielle talked about our property, who had nodded along about the addition and the back unit, found that very hard to look back on. Mark stopped speaking to Danielle entirely. Phyllis, gently, told her she needed some time. A cousin who had once defended Danielle at a family gathering, saying Evelyn was probably misremembering, called me a week after the ruling, apologizing, her voice unsteady, asking if there was anything she could do. There wasn't really. But I appreciated that she asked. Danielle's name and what had happened didn't stay contained to our family for long. She worked in a real estate office, and in that kind of office, word like this moves fast. I heard secondhand that she stopped going in. Then that she'd left the job entirely. Whether she resigned or was asked to, I never found out, and I didn't ask. Greg moved out about 2 months after the ruling. I don't know all the details, and I didn't go looking for them. What I know is that the two of them, who had spent years building this together, who had emailed back and forth about percentages and timelines, and her mother won't have a choice, couldn't survive being seen all at once for exactly what they'd done. Whatever had held them together, it wasn't strong enough to survive that courtroom. The criminal referral is still open. Arthur tells me these things take time, that the district attorney's office moves carefully, that nothing is guaranteed, but that the finding of fraud and the financial trail give them plenty to work with. Danielle knows it's hanging over her. I think in some ways that's its own kind of sentence. Waiting the way I once waited for an answer she can't control. About 4 months after the hearing, Danielle came to my house. I hadn't seen her since that day in court. She stood on the porch, the same porch where that beige envelope had once sat, waiting for me to open it, and asked if she could come in. I let her in. I made tea because that's what I do. We sat in the living room and she cried and told me she was sorry, that she'd never meant for it to go this far, that things had spiraled, that she'd been under pressure from Greg, that she hoped someday we could find a way back to how things used to be. I listened to all of it. I didn't interrupt. When she was finished, I set my cup down on its saucer gently and told her the only thing I had to say. You didn't make one mistake, I said. You built an entire future around stealing mine. She didn't have anything to say to that. There wasn't anything to say. A few months later, I sat down with a new attorney, not Arthur this time, but someone who specializes in estate planning, and made some changes. The house is no longer part of Danielle's inheritance. It never will be. Instead, when I'm gone, the property will become part of a trust, supporting literacy programs for children in this area. The kind of programs I spent my whole career believing in. Danielle spent 7 years trying to take a house worth $2.8 million from her own mother. In the end, she will never see a single dollar of it. But that was never really the worst thing she lost. She thought the worst outcome would be losing the house. She was wrong.